Parviz Jarabi, attorney at law, have been practicing for over 20 years. Our office is located by San Francisco Airport, specializing in employment law. Today's topic, write-ups, warnings, or performance review. In California, there are no specific laws that requires your employer to give you a formal write-up or warnings in writing, either during your employment or at the time of your being fired or let go. However, if your employer chooses to do so, then you must take a few steps, which I am going to explain here to protect your rights when receiving those write-ups. First, regarding your signature on these write-ups or warnings and whether you should sign them when they are handed to you. The answer to the question is yes, you may sign if asked by your employer to sign, but be careful that you're signing the write-ups only to acknowledge that you have received it, not that you are agreeing to the content or statement written in the write-up. In other words, by signing the write-up, you're not admitting that you did any of the acts your employer is accusing you of committing, but rather your signature is proof that you have received a copy of that write-up. So if you are approached by your employer and being handed the write-up or warning and asked to sign at the bottom, to make sure next to your signature and date, you write the following statements or wordings to the effect that, quote, by signing this document, I am not agreeing to the accuracy of its content, nor admitting to the wrongdoing I am being accused of. I am only acknowledging that I have been given a copy of this document, unquote. And always, to make sure you ask for a copy and or take a picture of the document you have signed. Also, if you strongly disagree with the content of the write-ups or the warning and believe them to be false, then you should also add a statement or wording in addition to the above statement saying, quote, I strongly dispute the accuracy of the statements written regarding my conduct as those accusations are false, unquote. I have seen these scenarios where employers start giving the employees written warnings or write-up, usually happen more often when the employee suffers a work-related injury or is asking for any type of accommodation related to disability or pregnancy. So to get rid of that employee, the employer starts giving the employee write-ups and warnings to create excuses for firing the employee when the employee has done nothing wrong to deserve those write-ups. This is a pure act of retaliation and discrimination based on your disability or report of a work-related injury and requesting accommodation. The employer is simply creating a false appearance as an excuse to argue later that the reason to fire that employee was not wrongful, but due to the employee's own misconduct, violating the company policy or poor performance. With respect to performance review, the same concept and concerns I just went over also applies to performance reviews. So the bottom line is that you must be very careful and be mindful as to how you handle these situations when you are presented with these documents. If your employer tells you that you must sign them, you may sign, but always write an explanation and statements I just told you and keep a copy in your file. Please contact my office with any employment law questions for free consultation. Please be sure to like and subscribe and turn on your notification.